Friends, we are back with our law snippet series, and today we will be discussing a very important judgment, Union of India versus Rajendra and Shah. It is a 2021 judgment of three judges, Nariman, Justice Nariman, Justice B.R. Gavai, and Justice K.M. Joseph. The majority judgment is given by Justice Nariman and Justice Gavai. Justice Joseph has given his dissent opinion in this case, and we will discuss the majority judgment in detail and discuss the dissent opinion briefly. All right, so let's start with today's law snippet. Okay, so now what was the issue in the judgment? The issue of concern in this judgment is the 97th constitutional amendment. This amendment has added Part 9B to the Constitution. Part 9B introduced cooperatives into the Constitution, but the issue was that the 97th Amendment was not ratified by at least half of the state legislatures. And hence the constitutional validity of the provision becomes non-tenable, right? So the subject, that is cooperative societies, fall under entry 32 of the state list under the 7th schedule, right? We know there are three lists provided under the 7th schedule: union list, state list, and the concurrent list. The lists are the fields of legislation, and they determine the competence of legislative power of the union and the state. Union had power to legislate on matters of list 1, right? States legislate on matters listed under list 2. Both union and state have the power to legislate on the matters of list 3. But in case of list 3, if there is a conflict between the laws made by the state and the center, then the central law will prevail, right? So the 97th Amendment affected changes at 3 levels. First, that is amendment to Article 19(1)(c) to form associations or unions or cooperative societies. Second, amendment to DPSP by adding Article 43B, that is about state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. And third, provisions under Article 243ZH to ZT. It is about incorporation, regulation, and winding up of corporations. Right? So in this judgment, the amendment to Article 19(1)(c) and Article 43B was not in question. Okay. Now it is beneficial to give a brief overview of the background of the 97th Amendment. Okay. So the statement of objects and reasons. It says that to ensure that the cooperative societies in the country function in a democratic, professional, autonomous, and economically sound manner. And provisions of the amendment, what were the provisions of the amendment? Part 9B was added. It provided for methods of incorporation, constitution of board, election procedure, and etc. Right? It also mentioned between Article 243ZH to Article 243ZT. Now, what are the reasons of this case? First, Gujarat High Court said that the Part 9B as ultra virus of Constitution for want of ratification by states as provided under Article 368 Clause 2. Okay. Then what happened after Gujarat High Court declared Part 9B as ultra virus of the Constitution, the union appealed in the Supreme Court. And the submissions of the union were they said that 17 out of 28 states, more than 50%, have enacted provisions in conformity with Part 9B. So even though the procedural criteria of ratification is not fulfilled, the states have in effect accepted it. They also said that the parliament in its constituent capacity can deal with state subjects. For example, Article 21A of the Constitution is added in the constituent capacity of the parliament, right? And Part 9B contains both multi-state cooperative societies and single state cooperative societies. And they said that doctrine of severability would have been used. Now, the counter submission by the respondents were, they said by introducing Part 9B, states' power in the matters of cooperative, the union government interfered by violating federal structure. They said that states have not ratified the 97th Amendment. They also mentioned that doctrine of severability is not applicable because multi-state cooperative societies and the state cooperative societies are deeply interlinked with each other. Right? Now, first we will discuss the contours of union-state relationship in Indian federalism. As discussed earlier, there are three lists: union list, state list, and concurrent list. Now, as per Hoshist Pharmaceuticals Limited versus State of Bihar, these lists are not powers of legislation. They are fields of legislation, right? Schedule 7 is present in the Article 246. There is a subject to clause present in Article 246 Clause 3, which provides that the federal supremacy in the matters of concurrent legislation. Now, these are the landmark cases which provide the important points for understanding union-state relationship. First is Kerala SEB versus Indian Aluminium Company Limited. It is 1976 case, which said that the meaning of the words, that is notwithstanding in clause 1 and subject to in clause 3 in Article 254, means that where an entry is in general terms in list 2 and part of that entry is in specific terms in list 1, the entry in list 1 takes effect notwithstanding the entry in list 2. So the principle here is a special power gets primacy over general terms. Now, second case is Goodrick Group Limited versus State of West Bengal. Now, in this case, the court said that before exclusive legislative competence can be claimed for Parliament, the legislative incompetence of the state legislature must be clearly established. Right? And the next case is Government of AP versus JB Educational Society. In this case, as per non-obstant clause in clause 1 of Article 246, the parliamentary legislation would prevail, notwithstanding the exclusive power of the state legislature to make a law with respect to a matter enumerated in the state list. So it's kind of in case of conflict between union and state, what would happen, right? Now, the next case is Greater Bombay Cooperative Bank Limited versus United Yarn. Here the court said that the use of the word exclusive in clause 3 denotes that within the legislative fields contained in list 2, the state legislatures exercise authority as plenary and ample as parliaments. And the next case is State of West Bengal versus Committee for Protection of Democratic Rights. In this case, court said, though undoubtedly the Constitution exhibits supremacy of Parliament over the state legislatures, yet the principle of federal supremacy laid down in Article 246 of the Constitution cannot be resorted to unless there is an irreconcilable direct conflict entries in the union and the state list. Okay. Now, in this judgment, the emphasis was on 3 points. First, entry number 32 of list 2, which says cooperatives come under the domain of the state. Second, entry number 43 of list 1, which says issues related to corporations, including banking and insurance, come under the domain of the central list. They don't mention cooperatives. Okay. And third, entry number 44 of list 1 is a wider provision that entry number 43 includes entry number 43 and includes other forms of corporations. Multi-state cooperatives can be considered to be included in this entry number 44. Right? Now, next point to see in this case, why ratification by state is required in case of certain type of constitutional amendments. Right? So it is provided under Article 362 Clause 2. The proviso to Article 362 Clause 2 says certain type of constitutional amendments need ratification by at least half of the state before the amendment gets presidential assent. And what are these? First, which are the amendments which are affecting Article 54, 55, 73, 162, 241, and 279A. Then amendments affecting Chapter 4 of Part 5, Chapter 5 of Chapter 6, or Chapter 1 of Part 9. And then amendments affecting matters listed in List 2 of Schedule 7, which is the issue in question in this judgment. And the amendment related to representation of state in parliament and provisions amending Article 368 itself. So if an amendment act touches all these areas, then ratification by at least half of the state is required. Now let's examine 3 questions. First, whether the 97th Amendment Act can be claimed to be a part of constituent power of the center. Second, whether 97th Amendment modifies an entrenched article as stated in Quixote-Holohan case. And third, whether 97th Amendment tried to curtail List 2. Now, with respect to the first question, that is whether the union can claim to use constituent power to introduce Part 9B and thereby dispense with the ratification by state requirement. I would say, though an amendment of the Constitution is the exercise of constituent power, which differs from ordinary legislative power, such constituent power does not convert Parliament into an original constituent assembly. And this power of Parliament is subjected to both substantive and procedural limitations. Substantive limitation is the basic structural limitation given in Keshwananda Bharti case. And procedural limitations are contained in Clause 2 of Article 368. We can take example of M. Nagaraj versus Union of India, where the court held that substantive limitations are those which restrict the field of the exercise of the amending power. Procedural limitations, on the other hand, are those which impose restrictions with regard to the mode of the exercise of the amending power. And both these limitations touch and affect the constituent power itself. And same theory was held in Quixote-Holohan also. Now, the twin challenges of substantive test and procedural test was recently used in Maratha reservation case. In this case, Constitutional Amendment 102 was challenged. One of the grounds of challenge was that it was not ratified by at least half of the states. The court held that the 102 amendment did not aim to alter the basic structure of the Constitution, and hence the substantive test is fulfilled. as far as procedural test is concerned, the amendment did not aim to curtail the power of the states. Hence, proviso of Article 368 Clause 2 is not attracted. But in this case, the state's power mentioned in entry 32 of the list 2 was curtailed. So non-ratification is a procedural infirmity. Now, with respect to the second question, we should refer to Quixote-Holohan case. It said that if there is any impact on an entrenched article, then it would require ratification if such impact is not insignificant. That is, that in effect, there is a change in an entrenched article, which significantly impacts the content of the said article that requires ratification. In the present case, the amendment makes change to list 2, where state has legislative competence. Hence, ratification is necessary. Now, with respect to the third question, I would like you to refer to H.M. Sirvai when he says changes can be made in the legislative list by addition, variation, or repeal of an entry, or by transposing an entry from one list to another. But the lists themselves cannot be repealed. In the present case, there is a variation of the entry 32 when 97th amendment was made. Hence, 97th amendment is a curtailment of the list 2. That is the legislative power of the state. Having discussed the ultra virus of the 97th amendment, we will see whether doctrine of severability is applicable or not. Now, doctrine of severability means only the offending part of the amendment which has the effect of altering the basic structure. It's struck down while the rest of the amendment is upheld. As per Quixote-Holohan, a composite amendment that was presented to the president for his assent, one part of the amendment requiring ratification from the states and the other not requiring ratification was severable. In the present case, the 97th amendment has two parts. First, affecting cooperative societies, and second, affecting multi-state cooperative societies. It is already proved that the provisions affecting cooperative societies is ultra virus. But its effect on multi-state cooperative has genesis on entry number 44 of list 1. Hence, this part becomes severable from the original. Hence, this part becomes severable from the original that becomes alive. Hence, doctrine of severability is applicable. Now, the ratio of the judgment is the 97th amendment and part 9b is not applicable to cooperative societies as they come under state list. 97th amendment and part 9b is applicable to multi-state cooperatives. Minority judgment that is given by Justice Joseph did not agree that doctrine of severability is applicable. He says Article 368 provides two limitations for constitutional amendment. And first limitation is that Parliament must scrupulously follow the procedure under Article 368. And second limitation is that Parliament cannot amend the Constitution by breaching its basic features. And he said the provisions related like Article 243ZI to Article 243ZQ and Article 243ZT to multi-state cooperative societies have not complied with the procedural provisions of Article 368 and hence they are stillborn. So they cannot be made alive by severability doctrine. Next, he said the provisions related to multi-state cooperatives and cooperative societies are deeply interlinked with each other and hence cannot be separated. But dissenting judgment has no binding value. Hence, we will go by the majority judgment, right? So thank you for watching this video. We will be coming up with the next video with another recent topic or